This conference will now be recorded.
Hello, everyone, and welcome to the third webinar in the Mid-Hudson Library System's HR Legal Issues series. My name is Casey Conlon. I'm the Library Sustainability Coordinator here at Mid-Hudson. And also with us today is Kirsten Kruger, Library Sustainability Associate and Communications Specialist. Kirsten will be serving as our technical support today, so if you have any issues with the webinar, don't hesitate to reach out to her. Sherry Fallon, who works as a compensation consultant at Cornell University, will be joining us again today, and this time she'll be discussing the top 10 legal mistakes by supervisors, the Wage Theft Prevention Act, Equal Employment, the Americans with Disabilities Act, and the Federal Family Medical Leave Act, among others. There will be a recording of today's presentation available at midhudson.org, and we'll send out an email later with a link to that recording so you can share it with any relevant library staff and stakeholders. This recording, along with the other recordings from Sherry's previous presentations, will all be available at midhudson.org. You have all been muted to limit some of the technical issues that can go along with webinars, but you're very welcome to ask any questions you might have. If you have a question during the presentation, please put it in the chat box. I'll be watching for the questions along with Kirsten, and we'll ask Sherry about them at key points during her presentation and after the presentation. So, Sherry, thank you for joining us today, and we're looking forward to your presentation.
Thank you, and good morning, everyone. This is the third and final webinar series, and we'll be going over some key employment legislation and the top 10 mistakes supervisors can make with these particular laws. The first thing we're going to do is we have an update to the Fair Labor Standards Act from the Department of Labor, and we will quickly go over that. And then if you have any questions on that, we're going to pause for a minute, and then we'll continue on with the rest of the presentation. So, top 10 legal mistakes. Number one, and this is the one that gets every supervisor, is failing to understand and follow the ever-changing wage and hour laws. The Department of Labor is continually adding updates and trying to send out letters of sort of clarity on who is exempt and who isn't. So watching their website is a really good idea as you go through, as you're trying to make decisions on whether someone is an hourly employee versus a salaried employee. So here's the update that we have so far for the Fair Labor Standards Act. In March of 2019, they did release a proposed updated salary level for exemption. The federal minimum, which would apply to the executive administration and professional exemption, they're proposing to go to $679 per week, or $35,308 per year. Again, New York State is higher, and as of December 31st, the New York State for the executive and administrative exemption in central New York went to $832 per week. So New York State is still higher. Where it will make the difference when they release the effective date of this is on the professional exemption, where it will go from $455 to $679 per week, and again, cannot be prorated for part-time. They are I believe they've just closed the comments section, and they did take into account all the comments they received when they wanted to increase it to it was like 47,000 at one point. So they did keep all those comments. They asked for additional comments, and they have closed that. We should be hearing something, we're assuming, by late summer, early fall of when this will be effective. Once they make it effective, you typically have 90 days to comply. They also, in this update, are proposing to increase the highly compensated employees from 100,000 to 147, a little over 147,000. So most of us don't use that exemption, but it is one that they're going to increase. And they're also going to make a commitment to periodically review and update the salary threshold. They're not going to make it a requirement, but they would like to look at it. And I believe they were looking at maybe every 5 years they'd reevaluate and look at that 10th percentile of the lowest census rate, which typically ends up being in the South. So they will make a commitment to review that. Is again, New York State is slightly different, and we are waiting to see what they're going to do as well. What they are not going to do in this round is change any of the duties tests. So they will remain as is for executive, administrative, professional, and the computer exemption. And if you have sales, outside sales, which I don't think most of us have. So that's where we are right now. I am assuming we're going to hear something by June of what they're going to decide and when it will be effective. And then again, you'll have 90 days to comply with that. Are there any questions on this new update?
So while we wait a minute, Sherry, you said that you have to monitor the website to find out about these changes. You said that's the best way to find out when these things are changing. Where would you look to see this info?
So it's www.dol.gov, and then you'll hit, there's an immediate link to the wage and hour law. So
Okay.
out there you'll see the duties tests, and there should be a bigger announcement, usually via I'm trying to think what website. You should get them. I get a lot from Bond, Shennick and King. They're an outside counsel, Coupa HR, things like that, and you will see the announcement of when this goes into effect. Usually, the New York Times will pick it up. The newspaper usually has a big headline on it. So, and again, as soon as I find out anything, when they're going to release it and make it effective, I will contact Rebecca and give her all the information for her to pass on to all of you,
Okay. All right.
because we monitor it pretty closely. Again, New York State is higher for executive administration, so we're safe there. But the professional exemption, which a lot of you would use for librarians, that's going to increase from 455 to 679, and we're just waiting for the date. But I
Okay.
will
Thank you.
pass anything on to Rebecca that I come across.
All right. Does anybody have any questions? You can pop them in the chat box and we can ask Sherry.
Okay. If they have questions later, we can circle back to this one. This one's pretty straightforward. This round of updates for this law. So. I'll move on to Wage Theft Prevention Act.
Yep. Yep. People can ask questions and we can cover them later if you guys think of something you want to ask later.
So back in April of 2011, New York State did an extension of the Fair Labor Standards Act, and it was called the Wage Theft Prevention Act. It required new employee notice and required written annual notification of pay. You had to offer these notices in the employee's primary language if it was anything other than English. And on the website where this law stands, they actually had a translation letter for many languages. At the time of hire or within 7 days, there had to be written advance notice of any change in pay, and that does still stand. And it must be signed by the employee and dated that they acknowledged that they received their change of pay in writing. Now, in 2014, you had to do this on an annual basis for not only new employees but current employees, and it was quite burdensome for a lot of employees. So in 2014, Governor Cuomo signed a bill eliminating the requirement that before February 1st of every year, the employers had to notify and receive the written acknowledgement from every worker. So what it did is when it originally went in April, you had 60 days to notify everyone of their rate of pay. And you could do electronic signatures, and everyone had to sign that. And then the following year, before February 1st, you had to receive another one, and that has now been eliminated and um, sort of tapped down. And however, if any employee gets a new change of pay, you do have to notify them within 7 days, and it has to be in writing, and they have to acknowledge it and send it back. And again, that can be done electronically, but it still has to be done and on their record. Failure to comply with any of those, you know, offering it in a primary language if it was other than English within 7 days, or and then have it signed and dated. The fine was $50 per day per employee that you did not send that acknowledgement out to. So the information that must be included in the letter, whether via email or on paper, was the rate or rates of pay, including overtime or commissions, piece rates, anything like that had to be in there. How the employee is paid, so it's whether by the hour, shift, day, weekly. The regular payday, so if you get paid on Thursdays or if you got paid on Wednesdays, that had to be included. The official name of the employer and any other names used for the business. The address, phone number of the employer's main office. So it wouldn't be if you had a branch at a different location. It has to be the main office or the main company's information. And any allowance taken as part of the minimum wage. So if an employee received tips or meals and lodging and those kind of deductions also had to be stated in the letter. And again, this was supposed to go out annually. However, they have backed down from that, and now within 7 days of a new hire or any employee receiving a pay change, and that does include your yearly salary increases if you receive them. The next two big mistakes that are made are mishandling employee complaint issues and creating a perception of retaliation if someone does issue a complaint and file it with human resources or their supervisor or um, head of the company. So, still with the Wage Theft Prevention Act, complaints can be made by any employee, person, or organization that acts on behalf of the employee. So the complaints do not have to come from employees themselves. It can come from a third party, such as a certified collective bargaining agent, or even an employee's relatives, if they were designated. The Commissioner of Labor can keep the name of the employee confidential until the disclosure is necessary for resolution. So this makes it very difficult for your Human Resources Office or even yourself to defend the complaint when you're not really sure who has made it. So, and it is at their discretion of when they think that is necessary. So it makes it a little difficult at this point. The Commissioner of Labor can now assess back wages, liquidated damage at no more than 100% of the total amount of wages, and they can now include attorney's fees. So, Wage Theft Prevention Act really increased the amount of money a company would have to pay. The DOL may assess civil penalties per violation. So, if you had 3 employees make the same complaint, it's per employee. So for the first violation, they would be fined $1,000, and that's if there's 3, that's $3,000. For the second violation, it would be $2,000, and then for the third violation, it would be $3,000. And for all subsequent violations, that $3,000 would stay in place. And it's also if an employee is awarded back pay or any kind of monetary liquidated damages, if the employer fails to pay that within the first 90 days, it's an automatic 15% increase in the award. So it's really important that should this happen and the DOL awards the employee any kind of back wages or liquidated damage, that it's paid quickly. There is a 6-year statute of limitations to file, and it starts from the date of the employee's complaint. So it can take a while, but if an employee is on their 5th year, 11th month, they can still file a complaint that happened within that 6 years, and you would still have to investigate it. If the labor commissioner issues an order to comply against an employer who does not pay that money who is owed, then 10 days after the appeal period ends, the DOL can require them to post a bond or provide a list of their assets. So if the employer fails to do that, they may bring a court case against them, and failure to provide the list of assets, they can impose a penalty up to $10,000. So this this particular law really puts the onus back on the employer to do the right thing and to quickly pay the wages. After, if you go through the appeals process, you still have the 90 days, but it's really important that you pay the fees, any back wages, very quickly. The wage theft also, they enhanced the rules against retaliation for employees, and this was the first rule of this kind. Threats are now included as a form of retaliation. So if an employee brings a complaint to you and you say, well, if you bring this complaint, you might lose your job, or, we might find we don't need your position anymore, that's a threat and that's illegal, and you could be found to be breaking the law. It is illegal for any person to retaliate, and it's not just the supervisor. So this can be anyone in the organization. The DOL can order the employer or person who acted against the employee to pay damages up to $20,000. So that's really important too, that, because people talk and things get out, that if an employee who's not even involved in the case, if they walk by and, it feels like an act of retaliation, that person could be responsible up to $20,000 in liquidated damages. The Department of Labor may also order the employer to reinstate the worker's job if they were fired, or they would have to pay the person for the lost salary or pay a lump sum in lieu of the reinstatement. So this particular act can really cost an employer if they don't do the right thing. Retaliation does carry criminal penalties, and the protection applies to any worker who alleges that the employer has done something the employee thinks breaks a labor law or an order issued by the commissioner. So even if the employee thinks they broke a law and may not have, but there's retaliation, you can still be in a lot of trouble. So this law really upped the game for any sort of retaliation by any person in the organization. So even if the employee is mistaken about the law and they acted in good faith, it would apply. So the Equal Pay Act, this law has been in effect for decades. It does mandate equal pay for equal work, including all contractual terms. So if you offer a male employee any kind of perks or additional pay for other types of work included in the contract, and you have a female employee doing the same thing, those same terms must be in their contract as well. Equal work is identified by effort, responsibility, skills, and working conditions. So it's really important that your job descriptions are accurate for each employee. Sometimes using just a generic job description can be problematic when you're looking at equal pay for equal work. And the jobs need not be identical, but substantially equal. And that's where employees fail to realize that they may be violating the Equal Pay Act. Um, by being substantially equal, I would tell you if about 90% of the jobs, 85 to 90% of the jobs are the exact same, and you're paying the female significantly less than the male coworker, you could be in violation of this law. Oop, oh, So the equality of terms provision covers all aspects of a contract and the benefits package. And here's just a quick list of things that could come into play if someone files under the Equal Pay Act. Any sort of performance-related benefits, overtime rates and allowances, hours of work, company cars, and sick pay. So if you offer this to one employee and not to another, and they have substantially equal jobs, you could be in violation of the Equal Pay Act. And the employee who files under this law, again, would get back pay. You would have to bring the pay up to the same levels, and you would have to offer, if you offered anything in a contract that is different from the other employee, you would have to include those as well. In 2009, President Obama signed the Lilly Ledbetter Fair Pay Act. This amended the Civil Rights Act of 1964. What it tells you, well, we'll go to Lilly Ledbetter versus Goodyear Tire and Rubber Company. And what happened was Lilly Ledbetter was a manager at one of the Goodyear Tire and Rubber Company stores, and there was a male counterpart to her. They were both managers, and the male was paid substantially more for the equal job. So they had the same role, but the male was paid substantially more. And so Lilly Ledbetter said that that's not right. We're doing the same job, and the company said no, it's different. And so she filed in court, and she won um, because they were substantially equal, and there was no difference. There shouldn't have been a difference in pay. And so former President Obama put into act where there's a 180-day statute of limitations for filing an equal pay lawsuit. Now, what the law also states is every unfair, unequal paycheck, discriminatory paycheck, restarts the 180-day statute of limitations. So every time Lilly Ledbetter received a paycheck and her male coworker received his, that restarts the 180 days. So it doesn't start, the 180 days does not expire after the first paycheck. It will continue for every discriminatory paycheck. And that's really important to know because basically it's endless unless the person leaves the company, and then they have that 180 days to continue to still file under the Equal Pay Act. So this is still in effect. It is still there. So just be aware of it if someone brings a discrimination lawsuit for equal pay to you. So under equal employment, it's a plan that identifies problem areas for protected class members and sets goals and actions to overcome those problems. Typically, for equal employment affirmative action plans, you have to have at least 50 employees. But what the Equal Employment Law does is it gives you protected classes composed of individuals identified for protection under the Equal Employment Laws and Regulations. Historically, the ones listed below: race, ethnic origin, gender, age, individuals with disabilities, religion. Those are typically protected classes. Some can change. Sometimes the age will change a little bit, or race, ethnicity, depending on where you work and the geography around you. That can change that a little. But this helps you identify and set goals for where there has been historical discrimination for certain groups. So this is the difficult part of the job. There's something called disparate impact versus adverse impact. So disparate impact occurs when employment decisions work to the disadvantage of protected class members, regardless of discriminatory intent. Adverse impact is defined as substantially different rate of selection, hiring, promotion, or other employment decisions which work to the disadvantage of the members of a race, sex, or ethnic group. So one where it's through selection and hiring and promotion, and the other one is made in any employment decision, whether or not you meant to do it. So these get a little confusing on how they're applied. Disparate treatment occurs when protected class members are treated differently from others, and again, whether or not there is intent. So just as you're looking at these and as you're doing your hiring, just keep this in mind. Most people do not disclose during the hiring practice. You can send out those cards that can come back, but they should go to someone who's not directly related or involved in your hiring decisions or your promotion decisions or anything like that. So that's where the Equal Employment Law comes into effect. The next big top mistake in dealing with employment laws is failing to promptly respond to accommodation requests. This one falls under the American with Disabilities Act. And this is where someone will come to you and just ask for some kind of accommodation, maybe to come in an hour later or leave an hour earlier due to a disability. And if you brush it off or don't address it immediately, they can file under the Americans with Disabilities Act. It does prohibit discrimination on the basis of disability in employment, and this does apply to state, local government, public accommodations, and commercial facilities. So this um, municipalities, state and local governments are not excluded from the ADA. One must have a disability or relationship or association with an individual with a disability. And disabilities are defined as a person who has a physical or mental impairment that substantially limits one or more major life activities. It must be documented by a physician. So an employee just cannot walk in and tell you. You do need to have a physician have it documented by a physician with a note. The person has to have a history or record of such impairment, and the person is perceived by others as having such an impairment. So if someone comes in to you with a note from the doctor asking for an accommodation, react very quickly and swiftly. And as long as it doesn't cause you substantial financial harm, you must comply with that reasonable accommodation. The ADA does require employers with 15 or more employees to be in effect, and that's most of us. So it's a law that applies pretty much to every employer, excuse me. It prohibits the discrimination in recruitment, hiring, promotions, social activities, and other privileges of employment. It restricts questions that can be asked about an applicant's disability before a job offer is made. So this is another place where you would be surprised that during the recruitment process, if you bring someone in for um, a job interview, make sure you talk to, if you have an HR office or legal counsel, about what you can and cannot ask. There are questions you cannot ask until after, and even after a job offer is made, if someone comes in and asks for an accommodation, and that's, you still have to comply with that. I would also, on your job descriptions, make it very clear about working conditions, and so that people know up front, if it says must be able to lift 50 or more pounds, and it's a requirement of the job, then typically you probably cannot make a reasonable accommodations, but that should be well known in the job description prior, even with the posting. So it's really important up front to be clear about some of those working conditions that maybe you cannot make accommodations. This law does require that employees make reasonable accommodation to the known physical or mental limitation of qualified individuals. And again, unless it results in undue hardship. And what they're talking about with undue hardship is financial. If it's going to cost you, if you have a library budget of $2 million, then it's going to cost you $100,000 to make the accommodation. The ADA will see that as an undue hardship. So again, this really does come down about how well those the job descriptions are written, and really those working conditions of what is expected of an employee. It does prohibit the employer from retaliating again. So most laws now will have a retaliation clause in them. So it's very, very important that you don't. If an employee comes to you with a reasonable accommodation, well, I don't know if we can do this, and maybe this job isn't just for you, that can be seen as retaliation. So just be really, really careful with the wording. So the types of workplace accommodations that the ADA thinks are reasonable and do not cause a lot of undue financial hardship for employees is just restructuring a job. Can someone else lift that 50 pounds? Can that be given to someone else? Reassign. Can you reassign some duties, like filling in for a receptionist, if like with carpal tunnel maybe? Can another receptionist do the typing or another admin assistant? Adjusting work schedules, time off for appointments, or a later start time because of morning drowsiness due to medications. Is it possible for them to come in a little bit later and leave a little later at night and still get their hours in? Flexible leave time, the use of sick leave for health reasons, extend leave without pay due to hospitalization and things like that. Can you give flexible leave time? Is that a reasonable accommodation that your company would be able to allow? Specialized equipment or assisted devices, the use of email to deliver daily instructions, or even the voice to text. Some of us use that on our phone now. If you have an iPhone, you can use Siri and things like that. Are there simple things like that that could be used to make that accommodation? Modifying a work site. Sometimes this one again, and it's all going to depend on what they're asking you to accommodate. Install wall partitions around a workstation to minimize distractions. Is that going to cause you undue hardship? Is that going to be too expensive? Providing special transportation or special parking space, and providing human assistance, maybe instead of readers and interpreters, provide a job coach or a mentor. So these are the type of workplace accommodations where it may not cause undue hardship, and you would be able to accommodate the request. So we have a scenario. So a job applicant tells you she has a mental illness, needs to come in at 10 a.m. instead of the normal start time of 8:30. The job is a secretarial position, and you need someone to answer the phones when you open for business. She works, can to answer phones we know for business. The receptionist is not there, and she works 9:30 to 5:30. So there's an hour where the phones wouldn't be covered. Can you require this applicant to come in at 8:30, and how should you respond to the request? So assuming that you already chose this applicant and you've hired her for this position, she was the most qualified person. Review the job description to identify whether answering the phones is an essential function. And that's really important in a job description, that you list those essential job functions and with working conditions. So in this case, it's a marginal duty. The main responsibility, and has main responsibility for answering the phones. You may not be able to require them to come at 8:30. Someone else may be able to answer those phones for you. Since she initiated the disclosure, you can ask her why she needs to come in at 10, so that together you can open a discussion and identify the accommodations that would work for both of you. You might also ask if there's any other accommodations she will need in order to do the job, so that it, as you get through, a couple months in, you don't realize that other accommodations need to be made. Just, you can ask once she initiates that conversation. You can ask up front. You may ask her to provide documentation of her disability as well. You are allowed to ask for a doctor's note to see if the accommodation needs to be made. So number 5 is failing to promptly respond to leave requests, and this one goes into the Family Medical Leave Act. It's really important that if someone comes to you and has the medical documentation, that you quickly respond to the Federal Family Medical Leave Act. And again, we went through this one, sort of the differences between this one and the Paid Family Leave Act with New York State. This one, employers must grant an eligible employee up to 12 total weeks of unpaid leave during a 12-month period for one or more of the following reasons. So this is the birth and care of a newborn child, for placement with the employee of a son or daughter for adoption or foster care. This one is to care for an immediate family member, spouse, child, or parent with a serious health condition, or to take medical leave for yourself. So paid family leave is only to care for another family member. This Federal Family Medical Leave Act you can use for yourself. And it's if you're unable to work because of serious health condition. And again, the FMLA you can take in 15-minute increments, so it's a little bit easier to apply than the Paid Family Leave Act. The serious health condition is defined as injury or illness requiring inpatient care, outpatient care, that requires continuous treatment and supervision by your healthcare provider. There's an incapacitation of 3 days or more where they can't work. So that's continuing treatment. A pregnancy, of course, and chronic serious health conditions. This does not apply to short-term common illnesses such as the flu or sinus infections and things like that. So this is a chronic serious health condition. It does not apply to stress or voluntary surgery. So just remember that that would turn over into your short-term disability. The law does contain eligibility guidelines based upon the number of hours worked. So the 12 months would be prorated. Employers can require certification and usually do from a medical care provider. The leave can be intermittent, so you don't have to take it all at once, but must be taken within that 12-month period. Employees must be able to provide reasonable notice of leave when that's possible. Again, pregnancies aren't always um, timely, so sometimes, as soon as you know that you have to go out or you're going out, you can notify your employer. FMLA should be counted concurrently with other leave time, and employers must designate the leave as FMLA to prevent double dipping, um, even if the employee does not request the designation. So it's really important in your systems to designate that this is for family medical leave so that you can take away from those 12 weeks. And this prevents someone from saying, no, this is short-term disability, and they're sort of getting both. So you can take your short-term disability, and when that is over, you can move to the family medical leave. And this does give the employer the right to return to the same or equivalent position, and that's the same with the Paid Family Leave Act. And one of the things I did include again was this chart to show you the differences between the two. FMLA provides 12 weeks of unpaid leave, and the paid family leave provides partial paid time off. And again, once we get to, I believe, 2021, it'll be 67% paid time off under PFL, and then the employee would be responsible for the other 33%. FMLA can be taken in 15-minute increments, so that's a little different. Um, PFL, you have to take full day increments. So if you're going out and it's for a paid family leave day and it's only for like maybe a 3-hour appointment, you take the whole day. The FMLA, you have to have a minimum of 50 employees to comply. So if you have less than that, you don't necessarily have to comply with the Family Medical Leave Act. You can choose to. Paid family leave, it takes 1 employee. So these are, I added this chart again because it's really, these two laws sort of can run into each other, and it's really important for you to know the difference. And again, FMLA is for you not only to care for a member of your family, but it is also for yourself, as where paid family leave is only for caring for another family member. And the employer has an option under Family Medical Leave Act to require the employee to use existing or vacation time, and you don't have to do that under Paid Family Leave Act. So this is a chart that probably is really important to put up when somebody comes to you and requests one of these, and you'll know which one to use. Again, I included this in my last presentation, and I'll leave it, and I put it back in here because I felt it was really important to know who qualifies as a family member under FMLA and paid family leave, and especially under the military caregiving. So this chart is also good probably to put up when someone comes and makes a request. You can quickly look at it and know who qualifies and who doesn't. So the last 10 of the 10 top legal mistakes I sort of put back here. If we have gone over them with the sexual harassment training and paid family leave and some of the other, even under the Fair Labor Standards Act. Failing to manage and resolve conflict before it escalates into workplace violence or litigation, this one really falls under the sexual harassment and hostile work environment law that we talked about that went into effect in October. If someone comes to you and you just brush it off as, differences in personality or employees being employees or whatever, this really can get you into trouble and cost hundreds of thousands, if not millions of dollars. So it's really important to take every complaint seriously. And again, listen to both sides. Everyone is entitled to due process and to be heard out. So it's really important that, this is where a lot of employers get in trouble, to really listen and to really do your investigation and have that policy in place step by step of how your investigation works. And remember that although employee A came in and made the accusation or complaint, both parties are entitled to their due process, and they're both entitled to be heard and listened to and get their side of the story. And just make sure that your policy states that and it's really clear how your investigations work. Failing to, and this goes into failing to apply the policies and procedures and employee discipline consistently. So if you are not consistent on how you apply the policies and it looks like one, is a little lighter on this employee versus this employee, and people start thinking there's favoritism and it's because she's your friend and you guys go to lunch together, or he's your buddy and he helps you build a deck or something. If it looks like you're showing favoritism, this can really get you in trouble, especially under hostile work environment and things like that. So make sure that every policy is applied consistently and fairly across the board. And any kind of employee discipline process that you have in place, make sure that is clearly stated in your employee handbook. It is really important that employees know every step of the way. And then when you get to the disciplinary end of things, they know exactly. Maybe it's a verbal, your first step is a verbal warning. Your second would be a written warning. Your third is maybe another written warning and a day of suspension or something. So just make sure all that is outlined. Number 8, failure to give constant feedback, good or bad, to employees, and failure to document if there is problems. And this includes, and this is where it always goes sideways, it's failure to conduct those honest and effective performance reviews. I can't tell you how many times we've been called by legal counsel and she's talking to us and asking us, is this document, you want to terminate employee, do you have documentation? Did you follow your policies and your procedures for this type of work, of this type of problem or complaint that was handled or brought to HR? So it's even during your performance reviews, I know they're uncomfortable and you have to have very difficult conversations sometimes, but it's really important to document those properly, to be honest, not mean, but honest and direct and effect, and so that they're very effective, so the employee knows what the issue may be, how to solve it, how they could, maybe work towards making that, their performance more effective for the employer. So it's really important that all of this is documented because it's the first thing legal counsel will ask you in the event you terminate someone and then they file wrongful termination. Do you have documentation? And unfortunately, a lot of times the answer to that is no. Um, so it's really, really, even a verbal warning should actually be documented in an email saying, we had this conversation on this date. This is what we discussed. And so, as much as it says a verbal warning, always put that in writing as well because it shows the first step in your policy and your procedures. Number 9, carelessly using email. We have all been there. And I'll tell you a mistake I made. I had been asking a colleague to do something for weeks and weeks, and I kept getting no response, or I'll do it, and it never got done. Unknowingly and by accident, I hit reply to all, and I said to my supervisor, I cannot believe she gets away with this. This is so wrong. How does she know how to do her job? And I did not realize I hit reply all. Now, I had said some other stuff in the email, but I reread it because you never send the email the first time you type it, and I had erased a few other things in there. So this just happens sometimes accidentally. We've had people send very unpleasant emails via a listserv by accident, not realizing that they had hit reply all, or we had a glitch in the email system once where this listserv would automatically pop into your CC and then it would go out to the entire listserv. So it's really important when you're using email to think about what you're sending. And when you're angry and you're typing that email, think about it before you send it, walk away, come back and reread it, and then ask a trusted colleague to read it because sometimes you can really get yourself in trouble there. And 10, again, failing to keep good records. So there is a 7-year statute of limitation for all employee records through the Fair Labor Standards Act. Keep any and all documents that you have for that employee. And again, it's failing to keep good records of any kind of performance issue or complaint or resolution of complaints. conversations you have, whether it's a quickly even scribbled on a napkin and put into their file folders, to keep good records. Because again, if a lawsuit comes back to you, you'd be able to provide evidence to your attorney of why this person was terminated or why this particular complaint went the direction it did. So these are really important things to remember when people come to you, even if it's a quick, this made me uncomfortable and I'm not sure. It's not really a complaint, but it may be. I would look into it and just document, document, document. It's the most important thing you can do, and it's the most helpful for you because we do have those laws now that we've talked about before where if you make a decision, like in the Fair Labor Standards Act, to exempt someone who shouldn't have been, they can now not only they can go after anyone who was involved in the decision. So it's not just HR or not just the company itself. They can actually go after the supervisor who said, yes, let's make them person exempt, and I think it's exempt for this, and wrote the job description that way. They can actually go after the supervisor now as well. So it's really, really important to keep those good records and document everything. So I think we went through that really fast again. It's hard when you don't have questions in between, but does anyone have any questions?
All right, if anybody has any questions, please put them in the chat box. Sherry, we had a couple questions come in.
Sure.
Can I ask about the ADA compliance? We have
Yes.
a lot of smaller libraries, so it looked like it said if you have less than 15 employees, you don't have to comply with the ADA
Yeah, I'm going by DA.
requirements.
Yes. So I would say I would look at your library and see how is it set up. Are you a branch of the Mid Hudson, which would give you more than 15 employees? And now 15 or more employees includes part-time, temporary, maybe students during the summer. So you have to be really careful about that.
Okay,
If
so nobody is a branch, but so that's not 15 FTE, that's 15 human beings on the
that
payroll, and that
yes,
would
that
trigger.
yes. So it's not. Yep. When they talk when these laws anyway talk um, 15 or more, or one or more, 50 or more for FMLA, they're talking about actual bodies. They're not talking about full-time positions. So yeah. So this could be, someone who is full-time, part-time, might come in for 2 hours a week. Students during the summer that you may hire. That adds to your 15 or more.
Okay, all right. If if you were trying to make accommodations for somebody, would they usually come in and tell you what the accommodations they need were, or would it be your responsibility as a supervisor or as the CEO of the library to try to figure out what kind of accommodation you would need to make for somebody?
So typically they will come in with the accommodation. So they will have a doctor's note saying I needed an accommodation for this. And usually what I have typically seen is it's actually written in the doctor's note. Like, we they have this disability. We're asking an accommodation for them to come in an hour later during the day, or an accommodation for like a text or a talk to text type program for someone maybe with carpal tunnel, right? And that's an accommodation. They will typically come in with the ask, and then it would be your responsibility to sort of ask more questions and see if, well, what if we made, would this accommodation suit you or something like that? If you have another way the accommodation could be made. So yeah, they typically will come in with that accommodation, and then you guys continue to have the conversation. Is there either any other accommodations you need, or you can suggest, well, what about this accommodation? It might work better, right? Whatever would be more helpful to the employee who's asking.
Okay.
So that's a little bit of a yes and a no question.
Mhm. So there's a line in the presentation, I'm not sure if it's on this slide or the other one, and it says something about perceived as having an impairment. And I
Right
was just
there. Yep.
wondering what that meant exactly, or what that means in practice.
Yeah. So this one's a little more difficult. So if they're perceived by others as having an impairment, so the easiest one would be someone who has a hearing impairment. They have, they have the hearing aid that sometimes you cannot see, but you know that they do have a hard time hearing, and they always ask in meetings to sit up front, or they have said, I have a hard time hearing. So they are perceived by you now having such an impairment, and they don't necessarily need to bring in a doctor's note. Um, but if they ask for an accommodation, like to sit up front, or can I sit closer here, because I need to hear, and you can, just you can tell because you can either see the hearing aid or something like that. That's perceived by others as having such an impairment. That's probably the easiest example I could give you. Most of the time, if someone, I'd say 99% of the time, if someone comes in for and asks for an accommodation, you can ask for that doctor's note and ask for them to have the doctor suggest what is a reasonable accommodation.
Okay. What about if somebody won't acknowledge a disability, like if they can't hear very well and it's difficult for them to do their job, but they refuse to acknowledge that they're having some kind of hearing loss? There's a
So
safe
that one,
space.
yes, that one's difficult. So if they don't acknowledge it, you can. So first of all, if it's affecting their work, you can have. It's again going back to those effective performance dialogues, and those conversations with the employee, saying, we realize that, you know we need you to do this, but it doesn't, but you're not doing it right. Is there something, that we could help you to make you successful here? You could, and even if they won't acknowledge it, maybe, we've decided to reorganize the seating a little bit in the office. We're going to move you up here. And you can do it quietly and just use it as an office reorg, if they're having a hearing issue, and if you think sitting closer to somewhere would help them, tell them you're reorganizing the seating in the office, and this is where they've been assigned. But if they don't acknowledge it, and and you've done something like that, and the work still isn't, they're not meeting their expectations, that does turn into a performance issue. And and so some of the onus for ADA is on the employee. Okay, it is on the employee if they're not performing in their job because they won't admit to something like that. You cannot force them to, and then it just turns into a performance issue, and that's okay. It's when
Okay.
they come to you and say, "I have this hearing impairment, and you don't, and I just need to move to this spot, or I need a little assistance, like with the computer or something," and you do not help them or make that reasonable accommodation. That's when the employer gets into trouble. But if they
Okay.
won't admit it, and you want them to be successful, and you've moved their seat and they're still not successful, well, that's just a performance issue, unfortunately.
hmm Okay. Going back to equal employment, you mentioned quickly, I think, cards that you send out in hiring or promotion process. Would you
Yes.
talk about those a little bit more, or what those are,
So,
or how?
yep. Usually, typically, when you're in the recruitment stage, anyone who applies for the job, it's like an applicant card, and they will get it. And you do not have to, you can self-identify, whether it's gender, race, ethnicity, anything like that. You can self-identify, and you send those cards back in, and it goes to a third party source at the employer. What it helps to show for employers, if you are sued or something, that for the cards that have come back, and again, you can track by postings and stuff like that. We said, 50 people applied, we only got 25 cards back, but we did. It shows you did your part for affirmative action, and that you're following the law, and um, you weren't basically discriminating based on, age, race, gender, or anything like that, because they will go back and look, and it helps the will help the company set affirmative action goals, because it will tell them sort of applicant rates under for protected classes for the cards that do come back. And again, they're not required, and companies still send them out, but it's hard because people do not, it's not a requirement to send them back, but it does help companies set the affirmative action goals based on those responses.
Okay. If anybody else has any questions, please just pop them right in the chat box. I had another equal pay question. In terms of equal pay, and I think what you were emphasizing was if people are doing the same job and they're performing in the same way, they should get the same pay. Would it be fair to pay somebody more or pay people differently based on seniority or how long somebody has been on the job?
So you can do that. And it's not how they're performing on the job. So equal pay is equal pay for equal work. Okay. And if once you throw performance in, and obviously if one's performing at a higher level than the other, you absolutely can pay them more because you have a justification for that. But if they're both working, like if they have equal work, equal pay, they've been there the exact amount of time, right? And they're performing the exact same, they should be paid as close to the same as possible. And yes, you can take into account, because you do have unions, if you have a union or even if you don't, you can take into account seniority. Absolutely. So if one person's they're doing the exact same job, but one's been doing it for 10 years and one person was hired 6 months ago, that person who's been doing it 10 years absolutely can be paid higher. So again, equal pay doesn't exactly take into account performance. It's just equal pay for equal work, and if one's performing better than the other, or absolutely you can pay them higher.
Okay. Going back to the annual notices that we were talking about
Mm-hmm.
earlier,
Yeah,
are all organizations required to do that, to give written notices to their employees each year?
that was all organizations. Yes.
Okay, so all our
So
libraries
I'm
should
going
be
by.
doing that? Okay.
Um, so in 2014, they did eliminate the requirement before February 1st each year. So now it's only if someone receives a pay rate change within 7 days of that pay rate change, that person should get written advance notice.
Okay. And you
Okay.
had,
So they did eliminate the yearly thing.
okay, so just when somebody's pay changes, you have to
Right.
update them and give them like a little notification of all.
Yes.
There was a handy list of all the things that you had to include in there, right?
Right there. So, if you do an annual salary increase prior to 7 days in advance, everyone that got that, if you do it on if you do it on anniversary dates or one set date, like we do ours on one set date, July 1st of every year, um, 7 days in advance, all those letters have to go out with this stuff listed
Okay.
in those letters. And again, it can be electronically. They have allowed electronic, and it can be, or it can be, a piece of paper. So however you choose to do that, and then have it acknowledged, you will be in compliance.
Okay.
Because it
So you
used
want
to
to,
be we had to send one 7 days prior to July 1, and then we had to get another notice in before February 1st because it runs on the calendar year. So, but they have done away with that.
okay. So,
Okay.
but you want to make sure that you document that people have received this?
Yes.
Okay.
Yes.
And in,
Put a copy of the letter, if you do it by letter or even email, in your employee folder, in the employee folder.
okay. In this, do you have to include information if somebody's like hours were changing that they were going to be working weekly, or is it just
Yes.
about, oh, you do?
I would do, if someone is changing their shift or their hours, I would still, because it does, especially for an exempt person, it changes their rate of pay. It does affect their pay. So basically anything that's going to affect their pay. So if they change hours, or if they start getting commission or stop getting commission, they go off commission pay, something like that. Anything that touches that pay, you would have to I would send a letter.
Okay, so if you readjust the schedule and this person's going to be working 5 hours instead of 7, then you got to let them know with a
Yes.
letter if you're going to do
Yes.
that?
Yes.
Okay, and that's for part-time workers too and full-time workers?
Yep. This includes everyone. Yes. Anyone on your payroll.
Okay. And are holidays and paid time off in here?
No. Nope, they did not include that. If for some reason, um, if you get if you take a day without pay, I would at least document that. Like if someone, oh, in 10 minutes, okay. If someone decides to, um, so if an exempt, and this mostly is for exempt people, if they decide to take a day without pay, I would have that written somewhere, probably an email. By the way, you have agreed to take this day without pay, so your weekly pay, or by semi-monthly, bi-weekly, however you pay salaried people, will reduce to this for this pay period. Yes, I would send that. Just so someone can't come back, why'd you reduce my pay? We didn't agree to this. You want to make sure all those agreements, and anything that would touch a person's pay like that and reduce it, is in writing and sent to the employee. It's sort of like that verbal warning.
Hmm.
It's supposed to be verbal, but I would still put it in writing saying we had this conversation on this date and this is what was said. It really does, it does cover you.
Okay. Does anybody else have any questions for Sherry while we're here about any of the things that we talked about today or anything from our previous webinars and presentations? Okay. Well, I guess if nobody has any other questions, if you think of any, you can email me and we can get in touch with Sherry and we can see if we can help you answer that question.
And again, any updates I receive on the Fair Labor Standards Act that exempt salary minimum going up, I will make sure I get to Rebecca or Kirsten or Casey for you guys to be notified of when that will go into effect.
Okay. And we'll make sure that you guys hear about it, you all.
Okay.
So yeah, so if there's no other questions, then we're going to close out the webinar. And we'll say thank you to everybody who joined us for this webinar and the other webinars that we did in the HR Legal Issues series. You'll be getting the recording later today, and have a good day.
Thank you.